All right, welcome back. I have a fun one for you today. At least I hope it'll be a fun one. So, gonna get a few things out of the way first. So, winter has finally decided to grace Salt Lake with its presence. And unfortunately, one of the side effects of winter storms is my pain goes through the roof. It feels like my non existent foot is getting zapped by lightning. So if you see me jumping out of my skin, that's what it is. And so there's no guarantees I get through everything I want to get through today, but we'll do our best. We'll see how far we get. No matter what, we're going to get through the cease and desist. The phone calls, the wellness checks might get kicked to the next one, but I'm going to try to get through all of them. And hello, Leonard Debbie. And is that Svi Krasner? And Kitty Wampus. So, yeah, that's basically where I am. And there, unfortunately, Sir Crow, there is no link. That's part of why I wasn't able to get through yesterday. Caffinated Kitti sent them to me, so huge thank you to Caffinated Kitti. So, straight from the source. But yeah. So while I'm getting warmed up and giving people time to get in, so normally, I should start off. For those of you who are new, hi, I'm Joe. I'm an attorney licensed to practice in the state of Utah. And yeah, this is in Illinois. The lives don't happen very often, unfortunately, cranky elder god. I enjoy doing them, but I have to try to keep to schedule to get them, and that doesn't happen. And so I end up recording videos about midnight. And you do not have to buy a coffee. I'm here in Utah after all. But that is a good reminder. So I held off doing it for a long time, but I did for the new year activate my channel memberships. That's not a direction, go out, become members. It's just a statement of fact. But yeah, so when I do a new case, I always assume I have a brand new audience. So if I've covered a legal concept before, I pretend I haven't, and I do it again. And frankly, with this case, I do have a largely new audience. Just looking when I cover delete laws and even Schofield versus Gillard, and my audience, according to Google Analytics, is about 75% male. Covering this case, the whole one video I've done with a few shorts cut out of that, has been 80% female. So clearly a different audience, which is great. I love it. But that means I need to, like I said, cover legal concepts I haven't before. And I was reminded of that because of a comment on one of my shorts, which that short was discussing how I have the lawsuit complaint opened on the screen, page 6, and I mentioned these statements here, reading from it. Along with the video, defendant Casey announced that she compiled a list of links to posts that Ms. Propson liked and contained transphobic and hateful rhetoric. And then the next paragraph, upon information and belief, none of the videos defendant Casey linked contain transphobic and hateful rhetoric. And I mentioned in my first video on this that that's a conclusory statement. There's show us the statements, show us, because this isn't good enough to survive a motion to dismiss. And the short I cut out of it, apparently it brought out all of the transphobes, frankly, because all the comments I got were transphobic, or at least, thinly veiled transphobic. And one of them had a clear misunderstanding of the law. And I'm not going to pull it up on screen because why broadcast, morons? But I do have it pulled up on my phone, so I'm going to read it and then discuss why it's wrong. And so that's sort of the icebreaker, get everyone in. So the comment says, the links and videos are part of the evidentiary filing. They don't have the links in their statement and normal court practice, but I'm sure the word normal is transphobic and hateful right now. So that's just wrong. It's wrong. So we did look at Rule 8 and Rule 12 of the Federal Rules of Civil Procedure, but let's refresh ourselves. So Rule 8, the claim for relief. A pleading that states a claim for relief must contain three things: a short and plain statement of the grounds for the court's jurisdiction. So in this case, that was why they have diversity jurisdiction. And thank you very much, Law Nerd Debbie. You're my very first member. So number 2, a short and plain statement of the claim showing that the pleader is entitled to relief. So that's the part we need to focus on. And then number 3, a demand for the relief sought. And then Rule 12, specifically 12b-6, is a motion to dismiss for failure to state a claim upon which relief can be granted. So what is a failure to state a claim upon which relief can be granted, keeping in mind Rule 8, the short and plain statement? Well, in the mists of time, as in pre-2007, the U.S. Supreme Court case that controlled was Conley versus Gibson, and frankly, this might have been sufficient. Upon information and belief, none of the videos contained hateful or transphobic rhetoric. The problem is, for the motion to dismiss, the court can only consider the facts brought in the complaint. It can't consider outside evidence. So when the unpleasant commenter says, well, that's in the evidentiary packet, that doesn't need to be there. It does if you want to survive a motion to dismiss. And so the current Supreme Court case law is a pair of cases, and it's Bell Atlantic versus Twombly from 2007, and then Ashcroft versus Iqbal 2009. And they combine, they're referred to in the legal profession as Twickball. And yes, I realize I'm on Wikipedia. That's not a great source, but I know what I'm talking about, so I know if it's right or wrong, and it's just convenient. And so the basically, this paragraph right here, I realize it's small, but I'll read it. But this paragraph summarizes the changes to the pleading standards. And so 2 working principles underlie the decision in Twombly. First, the tenet that a court must accept as true all of the allegations contained in a complaint is inapplicable to legal conclusions. So looking at, for those of you who have followed the delete laws lawsuits, his legal conclusions saying there was no probable cause to arrest me, therefore it was a false arrest. Well, probable cause is a legal conclusion. So even though generally in the motion to dismiss stage, the court has to accept the factual allegations in the complaint as true, but it does not have to accept legal conclusions as true. But second, only a complaint that states a plausible claim for relief survives a motion to dismiss. And determining whether a complaint states a plausible claim for relief will, as the Court of Appeals observed, be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. In keeping with these principles, a court considering a motion to dismiss can choose to begin by identifying pleadings that, because they are no more than conclusions, they are not entitled to the assumption of truth. I'm going to say that again. Pleadings that are no more than conclusions are not entitled to the assumption of truth. And while legal conclusions can provide the framework of a complaint, they must be supported by factual allegations. When there are well-pleaded factual allegations, a court should assume their veracity and then determine whether they plausibly give rise to an entitlement for relief. And the decision in Twombly illustrates the two-pronged approach. So none of the videos contain transphobic and hateful rhetoric. That's just conclusory. That is nothing but, it's no more than a conclusion. So it's not entitled to the assumption of truth. If they had put a footnote here with a link to the list as the footnote, it probably would have been good enough. But this is not. Now, I realize that's just for one of the claims, one specific legal conclusion or factual conclusion, but it illustrates it's a good illustrator for the Twombly and Iqbal standard for surviving a 12v6 motion to dismiss. So now that we've gone through that and I've given people a chance to show up, let's move on. So we have, and let's see. Let's zoom in 200%. So this is the motion to dismiss sent by Janet, or otherwise known as Jeanette Braun, federal attorney Jeanette Braun. But she deserves no respect, so she's Janet. And welcome, Paul Berry. You've been one of my longtime supporters, so thank you for joining as a member. I appreciate it. But yeah, so as I mentioned, Caffinated Kitti sent me this because I thought I'd find it online. I didn't. Caffinated Kitti is wonderful, and you should all subscribe if you're on TikTok because she's wonderful. And she mentioned she only redacted personally identifying information. So the redactions were her, but it really is only identifying information. But she also specified all of the bold, all of the highlighted, whatever is original. So that's Janet. And let's see. Find the place here that I want. So basically, one of Janet's claims is that Caffinated Kitti basically accused her of being an overzealous fan and not being a lawyer. And we discussed how the language of the email that Kitti sent to Janet and then posted on GoFundMe is not, it's different than how Janet classified it. She mischaracterized it. And so we discussed that. So I do understand how you have reached out with cease and desists to smaller content creators speaking negatively about Lauren the Mortician's scandals. And while I understand your desire to protect a creator you enjoy, if you were not legally obtained as counsel for her, and I speak on this via my platform, your actions are going to cause her significantly more strife. So that if, to me, that blows up the case, because she's not saying because you are not retained by her, because you are not her lawyer. She says if you aren't her lawyer, you're going to cause her trouble. That's not a factual allegation. So that alone, to me, it invalidates the claim. But the truth of the matter is, this cease and desist, if you ask me, it calls into question whether Janet is a lawyer. If I received this cease and desist, if I received this in my legal practice, I would question whether it was a lawyer. I would be asking for proof. I'd be asking to see their bar card. I'd at the very least be asking for their attorney number, because it's that bad. It looks like it was scrawled in crayon by an angsty teen. It's terrible. And I mean, the reality is, I'm not going to do it because I'm lazy, but I know a lot of you have seen Mad Catster's coverage, and he sent in a bar complaint to the Illinois bar. This really does rise to that level. It is bad. Why is it bad? Well, let's look into it. So, notice to cease and desist. Federal Rule of Evidence 408 communication. Well, let's look up Federal Rules of Evidence. So, Federal Rule of Evidence, Rule 408, compromise offers and negotiations. Prohibited uses. Evidence of the following is not admissible on behalf of any party, either to prove or disprove the validity or amount of a disputed claim, or to impeach by a prior inconsistent statement, or a contradiction. So basically, what we have here is the courts want you to work it out yourself. And if things you discuss in trying to work out a compromise can be used against you, you're never going to discuss it. So the court says basically, hey, the discussions are privileged. Anything, if you send a letter offering to compromise, it's privileged. It cannot be used against you. So this is just good policy. And Svi, so I haven't read the filings in the Billy Mitchell nonsense. I have followed the Carl Jobs coverage of it and some of Moist Critical's, and it's just, it's bad. So I'll just leave it at that. The Billy Mitchell nonsense is bad, and if I had been on it at the start, I might be covering it now, but it's too far in. I'm not gonna go back, and catching up would be a nightmare. But it was sent to Caffinated Kitti, redacted name, address, and it was sent. Well, sorry, it was sent to her mother's address, not addressed to her mother, but sent to the address. And it took me a second to process it because she has sent stuff to Kitty's mother, which is nuts. It's just, it's insane. So regarding Lauren the Mortician, blackmail, extortion, defamation, false light, copyright infringement, harassment, and stalking. Well, it's none of those, but go on, Janet. So, Ms. Redacted, I hope this email finds you well and in a centered and rational state of mind. I am Lauren the Mortician's federal civil attorney and am in receipt of your email below. Her federal civil attorney. I mean, would she like a cookie? Would she like a medal? She's a federal civil attorney. Do you know what it takes to be a federal attorney? Well, I don't know what a federal civil attorney is, frankly, because it's something that only really exists to Janet. But to be admitted to a federal court, so in order to practice in a federal court, basically what you have to do is you have to be admitted to practice before the highest court in any state or territory. So I am admitted to practice before the Utah Supreme Court. That also grants me the ability to practice before the Utah Court of Appeals. I've never practiced in the Court of Appeals or the Supreme Court, but it also grants me the ability to practice in the Utah District Courts, which I have, and the Utah Municipal Courts or Justice Courts, which I have. So I'm admitted before the Utah Supreme Court. And then what I have to do is I have to pay a fee to the federal court, to the federal district court, which I have in the past. I'm not caught up, so technically I'm suspended in the federal court, I believe, but that's fine because I haven't been. All I have to do is pay and make sure my PACER and ECF accounts are active, and boom, I'm back in. But basically, you've got to pay the fee and you've got to swear the oath again and you can practice. And then I can't, for the yeah, for federal courts of appeals, so like Utah's in the 10th Circuit, I can't remember what would be required for that. The Supreme Court, basically, you have to show up when the Supreme Court's in session, and someone who is already admitted to practice before the Supreme Court basically says, I nominate Joe to be admitted to practice before the Supreme Court. And then the Supreme Court says, you're good. And so that's what it is. And so for Janet to puff herself up, I'm a federal civil attorney. It's laughable. To me, at least, that is hilarious. It's, I mean, becoming a lawyer is an accomplishment. Becoming a federal civil attorney is not. It's just a fee. So moving on. The proper way to address me in communications is Ms. Braun. You and I are not on a first name basis. Or sorry, you and I are not a first name basis. Here I am correcting her grammar instinctively. That's, yeah, my brain doesn't like bad grammar, so it instinctively fixes it. But how Kitti chooses to address anyone, I mean, calling her Ms. Braun or Attorney Braun or whatever is respectful. And, you know, there is a duty of civility in court. But at the same time, calling her by her first name isn't uncivil. It wouldn't be breaching the duty necessarily. And basically, that's it, Linz. This is intended to scare a layperson. It's a lawyer sees it and they're going to laugh. But frankly, most lay people will laugh as well because it's that ridiculous. I mean, it's puffery is basically what it is. She's trying to big herself up, but she took it too far. She took it way too far. And so basically, yeah, it would be inappropriate to call her Janet in official communications, but I encourage it online. So Attorney Braun would also suffice. You proclaim to be a demon playing a game of chess against me while I am playing checkers. I am not playing any games. None of this is a game, and it is clear you have no respect for the judicial process. However, you are not playing a game of chess. Your actions make it undeniable that you are playing a game of Twister in the mud. I recommend you stop playing all games and give the situation that you have caused the respect it deserves. So, Janet apparently doesn't understand what shtick is, what an online persona is. Kitti is playing it up. It's how you build an audience. It's basically that's it. She got under Janet's skin, and Janet is pissed because she doesn't understand shtick. But it's also, you know, in copyright, so for copyright, one of the things that makes it fair use, makes it so that it's not an infringement, is parody. But this is it's hyperbole. It's intentionally nonsense. But it's also in defamation. It clear hyperbole and parody, and it's not a statement of fact. And the word I'm trying to think of is escaping me right now, but it's just nonsense. So Janet is being toyed with because she doesn't understand human interaction from what I've seen. It's just bad. And that's it. NF Cat. She's trying to make a name for herself. She's the more high profile clients she can get and get her name out there, she thinks that's good advertising. But she missed a step. You know, I use the South Park underpants gnome example too often. Satire, Paul Berry, that's it. Thank you. Satire is protected. It's you turn the live stream on and your brain goes empty. But satire, that's what I'm after. But going back to the South Park underpants gnomes, you know, on South Park it's underpants ? Profit. For Janet, it's high profile clients ? Profit. But I can tell you what the question mark is in this case that she's missed. It's competence. If you have high profile clients, you have to competently represent them. You can't make a mockery. You can't submit bullshit. You can't send a cease and desist like this that is going to get you laughed at. That's going to make you a mockery, and people are going to see this, and that they're number one, they're going to say, you know what? Maybe I don't want a terrible lawyer. I don't want to lose my case because my lawyer is laughable. But number two, maybe I don't want the bad attention this is going to bring. Because, as I've mentioned, this is the Streisand effect on steroids. If Lauren the Mortician had simply done a copyright strike on Caffinated Kitti on her own, she would have got bad press, yes. But you know, the internet moves so fast that we would have forgotten in a week. Instead, she made sure it's an ongoing story with a lot more coverage than she expected. I mean, I wouldn't be covering it because I wouldn't have known about it. But you know, it's you reap what you sow, and it's bad. And Pat's Cats. So yes, she can sue for bad lawyering. The problem is this hasn't played out yet, so I can't say for sure. What I do foresee happening is there could very well be a suit for malpractice in the future, because depending on how she has obtained a waiver of attorney-client privilege by being co-plaintiffs, that she could run into massive problems, just because basically the attorney-client privilege on the copyright nonsense has been waived by being co-plaintiffs, because it's become something that's discoverable. It's been made an issue in litigation. So it's just bad. And thank you for becoming a member, Pat's Cats. And I would never ignore a cease and desist, because basically a cease and desist doesn't carry any legal weight per se. It's basically a stop or I'll sue. So no matter how bad it is, it basically it's designed to put you on notice that you're facing a potential lawsuit. Now, they, you know, and frankly, yeah, they do have a duty to their client. Well, first off, they have a duty not to bring absolute garbage into court. If they know a case is frivolous, a lawyer has a duty not to take it. Like if there's a case that I don't fully believe in, but I can make an argument, it wouldn't be a violation to bring it. Like if I know it's if I know case law doesn't support me, but I have a good faith argument that the case law is wrong and needs to be changed, then it wouldn't be frivolous. It might still be laughable, but it wouldn't be frivolous. So, and discussing the Streisand effect reminded me just now. So I'm disappointed in the chat. So as I mentioned, I'm new to this, at least this controversy. This is my introduction to every one of the characters at play. So for those of you who do know, I'm disappointed in you. You should have told me I had the wrong person on my thumbnail for the first video. The dumb blonde, I can't remember her name, but I was watching a CC Suarez video. Like I said, I'm learning the lore as I go. But I was watching a CC Suarez video and realized that the dumb blonde is a different content creator. To me, I Googled Lauren the Mortician pictures and I trusted that. And to me, it was a glamour shot with an angle and no glasses. So I'm just, if I get stuff like that wrong, please tell me. Please tell me so I don't look like a jackass. So, but continuing on, this is going to take ages. You also claim that you will, in so many words, do demon things in the very near future. What are demon things? Once again, that's satire. She's not going to summon the hounds of hell. So when she says demon things, it's not a threat. It's satire. It's shtick. It's her online persona. I mean, like we'll get to it, but in the lawsuit itself, and I think in the cease and desist, Janet talks about Kitty's statement about, I'm here to trigger the men or whatever. I can't remember exactly how she puts it, as if that's a claim against her. In my very limited interaction with Kitty, she's lovely. last I checked, I'm male. Kitty's been lovely to me. She has graciously provided me with information. She has graciously shared the shorts I put on TikTok. Does that sound like a man-hating demon to you? But like I said, Janet doesn't understand human interaction. She doesn't understand shtick and satire, and it's nonsense. And Pat's Cats, I did watch Runkle. Like I mentioned, it was Runkle's video where I learned that the lawsuit had been filed. For a few days before that, I had been following Marquis's discussion of the copyright nonsense, and I had been thinking, maybe I should make a video and review whether or not I think this is a copyright violation. And I still intend to. I've got to go through, get the videos, and actually do the review, but I still intend to. But in the meantime, the lawsuit was filed, and so, hey, that's even better for me. And yes, Janet is the lawyer, Jeanette Braun, federal civil attorney. And it's just laughable. And that's it. I don't know if she ignores the sarcasm or if she just doesn't get sarcasm. Like, I'm, as you can tell, very sarcastic, and there are people that don't get it. Like, so as my regular viewers know, my brother lives next door and with his wife and 3 kids. His wife is from Southern California primarily, and so historically, when her mother comes to visit, now from Pennsylvania, but when she comes to visit, or when her aunt comes to visit from Southern California, they tend to stay in the guest room here because there's less room next door, which it's great. They're family, even though they're technically not my in-laws, they're my brother's in-laws. But the aunt does not get sarcasm. Like, you can see the wheels turning in her head when my brother's just as sarcastic as I am. And you see the wheels, the gears in her head processing, and she says out loud, "This is sarcasm. You didn't actually mean that." Whereas, like, as you know, I did my master's in finance in England, and in England, that there's this thing called banter that Americans don't tend to get, where you sarcastically rip into your friends, and they don't get offended. They rip into you right back, and it's fun. So my guitar teacher is from England. He's from London. And so I was always one of his favorite students because he had to walk on eggshells a little bit with most of his American students, because if he ripped into them the way he ripped into me, they'd get offended. Whereas he knew with me, I gave as good as I got. But Janet, I think, might not be ignoring the sarcasm so much as, like my sister-in-law's aunt, not getting sarcasm. So the British TV show is Rumpole of the Bailey. We're talking about Ian Runkle, the Canadian defense attorney up in Alberta, who he has the YouTube channel playing on Runkle of the Bailey, or playing on Rumpole of the Bailey, and so it's Runkle of the Bailey. So just a clever play of words since his name is Ian Runkle. And his channel is much bigger than mine. He's covering this case. He, like Caffinated Kitti, is wonderful to deal with. I mean, you know, when we had that sovereign citizen shooting up in Davis County here in Utah, you know, I, as at the time, a 1,200 subscriber channel, reached out to Ian, who at that time was 240,000, and a couple others, and said, "Hey, are you willing to come join me and talk about it?" And Ian did. He, you know, no ego, despite me being tiny and him being massive in comparison. So, and he, even though he's Canadian, he covers lots of American cases because, you know, it's the same process that goes into analyzing them. So yeah, go subscribe to Ian at Runkle of the Bailey. He's good. But moving on, you intended this to be a threat to others based on the connotation and context of the statement. Demon things is not a threat. After seeing your multiple irrational and erratic posts on social media over the weekend, along with your TikTok live stream, I am worried that your mental state is unstable and that you may hurt yourself or someone else after reading this email. I believe that you are not going to take the news well, that you are wrong. If you have not composed yourself yet and are still spiraling, please stop reading here and make sure you have someone from your support network that you trust to be with you while you read this. Heed this trigger warning. That I have no words. I mean, that's it. That's it. She's worried about someone's mental state, but she's not a mental health professional. And once again, Caffinated Kitti's shtick, her online persona, is not her mental state. You know, as I mentioned, I'm sarcastic. Frankly, you guys don't see it as much, but I'm a shy person in real life but once I do warm up to someone, I talk too much. So when I was, you know, I'm still a small channel, but when I was a little itty bitty channel, and live streaming the Darrell Brooks trial, I mentioned how I'm generally pretty quiet and reserved, and the people in the chat were like, "No, you're not. You're waving your arms like a muppet and yelling and screaming and at the trial." And it's like, yeah, that's for you guys. That's to try and add entertainment to the stream. That's what Caffinated Kitti is doing. That's not a mental break. That's not mental illness. That's entertainment. Does you know, the trying to think of pop culture, my outside of Star Wars, my pop culture knowledge is terrible, but the Angelina Jolie and Winona Ryder movie from 25 years ago, where they're in a mental institution. Would Janet call in a wellness check on Winona Ryder saying, "Well, she's clearly mentally ill. Did you see her in that movie?" That's a good point. This isn't a petting zoo. This is an animal safari, arms and legs inside. So that means don't contact Janet. Don't leave bad reviews. Don't do anything unless she has personally reached out to you. She's for entertainment only. So any comments you have for her, leave in my video. Don't contact her. Don't contact Lauren the Mortician. Pretend they don't exist except here or on Caffinated Kitty's channel or Runkle or Marky or Mad Catster or Do We Know Them or Bekah Day or whoever else. And so, yeah. And thank you. Girl interrupted. That's what I was after. So yeah, basically it's just heed this trigger warning. To me, that's so dismissive of Caffinated Kitti. It's phrased as if it's concern for her mental health, but to me, it's dismissive. I think this little of you that I'm going to dictate everything to you. I'm going to dictate how you should receive this. I'm going to dictate how you should perceive this mentally. And that's it. It's concerned trolling. It's trolling in, yeah, just concerned trolling. That's a good way to put it. And that's it. It's condescending. It's veiled as concern, but it's just condescension. It's awful. I hate it, and it is threatening. But then a cease and desist is supposed to be kind of threatening in that it's, stop or I'll sue. But that's not blackmail. It's not. So, yeah. Yeah, Lauren, from what I've seen, like I said, I'm new to this cinematic universe. She seems like she doesn't fully understand, even though she's on social media. She is a content creator. She doesn't seem to understand. And if, just like delete laws, if I use someone else's video, that's fair use. That's fair use. So if I see a parent doing something that I think is dangerous, I can freely use their video because that's fair use. But if someone wants to criticize me, I'm looking at you, Jamie Grayson. If someone wants to criticize me, well, that's a copyright violation. So rules for thee and not for me. And thank you, Izzy. You're the best. And thank you, Calico Bell, for becoming a member. So the cease and desist portion. You do not know everything that you think you know. Your conduct directly violates several laws and legal principles, many of which potentially have both criminal and civil activities. I don't know what she means by criminal and civil activities. I would have put consequences, but what do I know? I strongly encourage you to hire attorneys, particularly a federal civil attorney and a federal criminal defense attorney. Yep, I mentioned that earlier, cranky elder god. I'm lazy, so I'm not going to send a formal ethics complaint, but I think Mad Catster is on the right track in sending one, because this is that bad. While this email is only intended to address your civil violations, I provide the potential criminal violations for your edification. In your email below, you admitted to copyright infringement and confirmed you are conspiring with redacted against my client. No, she didn't. We'll look at the email. I think it's in this, but Caffinated Kitti did send it to me. So if it's not included as an exhibit on the cease and desist, like I believe it is, we will look at it. It is in your best interest to hire an attorney before sending me any further communications. You are hereby demanded to immediate cease your malicious activities, which includes sending emails and posting on Reddit and other social media platforms, blackmail, harassing, extortion, defaming, false light, and copyright infringement claims against my client. And that was hard to read with all its grammar errors. I mean, conjugate. It's not you are demanded to immediate cease. It's immediately cease. Conjugate, conjugate, conjugate. You look dumb. There are posts on various platforms with the username Caffinated Kitti. These actions are not only morally reprehensible, but also illegal. Guess what, Janet? Morally reprehensible is subjective, and it's not illegal. We do not, despite the efforts of some, we do not have morality police in the United States. If it's not illegal, it doesn't concern you. Morally reprehensible is laughable. Your morally reprehensible, I might find high comedy. Sorry, Cynthia. I try to keep up with the chat. Well, I try to strike a balance. It's nothing against you. You are appreciated. I do appreciate you being here. You may think that because you are a demon, as you have proclaimed, U.S. laws do not apply to you. You are, in fact, human. And U.S. laws, along with international laws, do apply to you. Once again, it's her online persona. It's shtick. Caffinated Kitti, do you think you're a demon? I mean, maybe I asked the wrong question to the wrong person. Janet, do you think that Caffinated Kitti thinks she's a demon? Or are you too stupid to understand satire, to understand acting. You do realize, Janet, Star Wars isn't a documentary, even though it says a long time ago in a galaxy far away. It's fiction. You do understand that, don't you, Janet? And I'm reminded. I was going to ask this question earlier, but forgot. So the collective for the defendants in this is the girlies. The GoFundMe is either Janet or Lauren versus the girlies.com. And so what's the collective for the plaintiffs? Something preferably that won't get me canceled. What, instead of the girlies, what do we call the plaintiffs? And unfortunately, it isn't. So the deluded versus the girlies. Please note, this is not an attempt to restrict legitimate free speech, and we believe that the internet and social media platforms are important mediums for dissemination of accurate and truthful information for fair comments on issues of interest. So, a murder of Karens. What would a collective of Janets be? A collection of Janets. But for instance, if you wanted to make a video discussing your opinions or making true statements of fact, that would be within your rights. Your activities, however, unlawfully violate my client's rights and are not protected by your First Amendment rights. Once again, I highly encourage you to hire an attorney, as this is a serious matter. Ooh, that's a junket of Janets or a coven of Janets. Although maybe a coven of Karens. I do like alliteration. So, yeah, that I just don't. I don't want to call this gaslighting, but it is. It's you are trying to restrict her free speech. You are trying to stop her from the fair use of your client's material. You are trying to get her to stop talking. So, not too political. I'm not a political channel. If it's funny, though, I'll laugh. So, yeah. But blackmail, extortion, and coercion. Unless she's a more, then it's coercion. Sending threatening emails and posting threatening social media posts under the username Caffinated Kitti that demand something of value in exchange for not disclosing potentially damaging information is a clear violation of blackmail laws. Under 18 U.S.C. Section 873 and 876, blackmail is a criminal offense. Whoever, with intent to extort from any person any money or other thing of value, knowingly so deposits or causes to be delivered as aforesaid any communication with or without a name or designating mark subscribed thereto, addressed to any other person, and containing any threat to injure the property or reputation of the addressee or of another, or the reputation of a deceased person, or any threat to accuse the addressee of any or any other person of a crime, shall be fined under this title or imprisoned not more than 2 years, or both. And that's I don't understand how she thinks any of this is blackmail, because it's not. Caffinated Kitti has not tried to extort her. She's not trying to get anything of value or get her to unlawfully get her to do something. It's basically it's that this is dumb. It's Caffinated Kitti made a video that is protected by fair use. Janet doesn't think so, and Caffinated Kitti stood up for herself. But apparently that's blackmail in Janet land. And I don't get it. I don't get how she made this leap. And that's what I believe it is. I believe she's the easiest way to get someone to stop talking about you is to take away their platform. And false copyright strikes have been known to take away someone's platform. I think that's the goal. And basically this is filibuster. It's if the or even better, I think a better word than filibuster is it's a gish gallop of nonsense. It's throw everything at the wall, and it's hard to respond to everything. And the more nonsense she throws up, the greater the chance she thinks that there's going to be something that frightens off her opponent. But in this case, it's such nonsense that instead of being threatening, it's laughable. So yeah, it's filibuster, it's gish gallop, it's just entirely nonsense. So that is a good point. That is a good point. The coven needs to be reserved for the good witches. Yeah, for those of you who follow the sovereign citizen stuff, Judge Middleton in St. Joe County, Michigan, calls the sovereign citizen nonsense Jabberwocky, Borogrove, borrowing from Lewis Carroll. So this is legal Jabberwocky. It's the cease and desist equivalent of Jabberwocky. So here is one example of you blackmailing / extorting / coercing my client from your email below. I do understand how you have reached out with cease and desists to smaller content creators speaking negatively about Lauren the Mortician's scandals. And while I understand your desire to protect a creator you enjoy, if you were not legally obtained as counsel for her, and I speak on this via my platform, your actions are going to cause her significantly more strife. I would imagine it would reflect very negatively on you and your practice as well for you to attempt to use your personal law firm to intimidate people because you don't like what they have to say. You should patch me in with your business development and PR team. I'm sure they'd have some interesting advice for you. This statement of yours is you attempting to extract a thing of value from me and or my client with a threat to injure her reputation. You have made other statements in your videos posted on TikTok under the username Caffinated Kitti. Civil remedies are available for blackmail, extortion, coercion in many states. And that's just complete and total misrepresentation of the statement. That was not coercive. That's such nonsense. I'm speechless that she thinks this is blackmail, because this isn't saying stop filing false copyright strikes or else I'll expose you as being terrible. And that, frankly, even that wouldn't be like saying, hey, stop doing this illegal thing or else I will make it public that you are doing this illegal thing. Blackmail has to be to get you to stop doing something that you are legally allowed to do. So, like, even if Caffinated Kitti were trying to extract something of value, this wouldn't be blackmail because she's saying, hey, stop doing this thing that you're not supposed to be doing. You are not supposed to be filing false copyright strikes. So telling her to stop it's fine. It's perfectly allowable. It's encouraged. But she's not saying stop doing this for something of value or for personal gain. Well, I mean, it is for gain, as in her channel isn't under threat if she's not receiving false strikes. But the reality is that she's just saying, hey, this looks terrible, what you're doing. You need to stop so that you don't continue looking worse and worse. That's not extortion. That's not blackmail. It's nonsense. Other than, powdered wigs would be cool, but they're too expensive for me. So, I mean, suits are expensive enough. I'm happy. So further, in your email below, you confirmed that you are working and conspiring with Redacted against my client. You actions, once again, your actions, maybe proofread your nonsense, Janet, but you actions may reach the level of organized crime. And again, I highly recommend you hire an attorney before contacting me again. It's never RICO. It's never RICO. RICO is the legal equivalent of lupus. For those of you who watched House MD, it's never lupus. But it's also never RICO, except in the rare occasion where it is. So, once again, This is a mischaracterization by Janet. She's not conspiring. If it's what I think it is, it's Caffinated Kitti said, "Hey, the person whose video I used, because this wasn't even Caffinated Kitti directly using Lauren the Mortician's video. This was a reacception. It was Caffinated Kitti reacting to someone else's reaction of Lauren the Mortician. And Caffinated Kitti got permission from that person, from the middle. Apparently, getting permission to use someone's reaction content in Janet's world is conspiracy, is RICO, is conspiracy. It's nonsense. This I don't understand how in Office, the movie Office Space, what's the character that makes the board game jump to conclusions? Janet could make money jumping to conclusions because she's great at that. She's great at jumping to conclusions. And that's it, Kevin Campbell. Permission would be a defense. So if I got permission to use someone's video, if I got a license, I wouldn't need to rely on fair use, because fair use is a defense. Janet is right. Fair use is a defense to copyright. But you don't need a defense to copyright if you have a license. So, like, as many of you know, my absolute favorite band is Led Zeppelin. Led Zeppelin is famously protective of its music. They generally don't let anyone use it. It's in very few movies. It's in very few advertisements. It's on the radio or whatever other music. I've got all the vinyl records out in the other room. But Cadillac famously, for the very first time, got a license to use Led Zeppelin's song Rock and Roll about 20 years ago for commercials. So that wasn't fair use. That was using their copyright under license. So Lauren using this other person's video, the middle person's, that would be she received a license to use at least portions of her video. Now, if that video were infringing, it would still need a fair use analysis. So Caffinated Kitti would still need to have fair use as to the portions of Lauren the Mortician's video. But it is a very good point, Kevin Campbell. Yes. Permission, it takes you out of the fair use ballpark. But yeah, Weird Al doesn't need permission because parody is protected. But Weird Al is a good person, so he gets permission. So, like, most musicians consider it an honor to be parodied by Weird Al. Like Kurt Cobain says, he knew he had made it when Weird Al did a parody of his song. Whereas Paul McCartney, a famous vegan, Weird Al wanted to cover his song Live and Let Die as Chicken Pot Pie. And Paul McCartney said, "You have my permission if you change it to Tofu Pot Pie." And Weird Al said, that doesn't quite roll off the tongue. So he left it. But he could have just made it anyway, because it's parody. So yeah, but Janet doesn't understand. Parody is protected. Commentary is protected. Satire is protected. But that's it. Unfortunately, TikTok seems to not have as robust protections against false strikes, but I'm fairly TikTok illiterate. So yeah. Harassment. Continuously sending harassing and abusive emails and or other posts on social media platforms like Reddit and TikTok can constitute harassment, which is illegal in many jurisdictions and is a crime at the federal level. See 18 U.S.C. Section 2261. A person convicted of stalking under federal law faces up to 5 years in prison and a $250,000 fine. If the defendant's unlawful conduct results in the death of or physical injury to the victim, a conviction can land them in prison for 10 years, 20 years, or even up to life. Civil remedies for harassment vary, and the laws can be found in every state. As you have confirmed, you have worked with Redacted to send her email to my client. And that's it. How did we get to stalking? Is Caffinated Kitti following her in the street? Is she showing up at her house? Making videos about someone is not harassment. It's not stalking. It can rise to that level, but like 90, well, so I spent 2 straight months almost covering Daryl Brooks. Was I stalking him? Was I harassing him? No, I was just covering him. I was making videos about him. And it's allowed. It's allowed. It's free speech. So defamation / constitutional rights violations. You have posted false statements and allegations on public platforms about my client, and the statements are defamatory, damaging my client's reputation. Why, yes, Mr. Mimsy, filing a false wellness check could be considered harassment. So we'll get to that. The way we're getting through this, that'll probably be kicked off to the next video, but we'll see how far we get. Your statement that you caught my client interacting with extremist right content and hateful anti-trans posts as well in your TikTok video is a false statement of fact. What exactly was anti-trans in any of those posts? You failed to identify one single sentence, element, or other identifier that supports your claims. None of the posts are hateful anti-trans posts. What you are doing here is smearing my client and violating her constitutional right to associate with whoever she pleases. Mr. Rittenhouse was found not guilty by a jury of his peers. With your rhetoric, it is clear you have no respect for the judicial process. Further, you have failed to state any true fact that shows my client supports Mr. Rittenhouse or Mr. Rittenhouse's specific actions. You have also failed to state any true fact that conservative Ant is anti-LGBTQ+. After all, he is gay himself and in a gay relationship. Well, being gay doesn't insulate you from discrimination against other people in under the LGBTQ plus umbrella. I've heard stories of gay people, discriminating against bi people. You're not really gay, so you don't count. You're not one of us. People, gay people or bi or whatever, that, as they're not trans, they can discriminate against trans. But it's even, you look, there's the well-known trope of the self-hating Jew. Just because you belong to a group doesn't mean you don't hate others. You don't discriminate against others within that group or within sort of peripheral parts of the group. As you said, anyone can be a jerk to anyone, and just that I've got a simple solution to that: don't be a jerk. And stupidity knows no bounds. So, as I mentioned, I haven't reviewed these posts. Exactly, Weird Housewives Club. There's biphobia from within and outside of the community. So I haven't reviewed these posts. I intend to, but I haven't looked them up yet. So I can't give my opinion. But when I do review them, that's all it will be, is an opinion. So opinion is protected. Opinion is not defamation. Caffinated Kitti is free to give her opinion that conservative Ant has transphobic posts. And the only statement of fact is that Lauren the Mortician interacted with those posts, that she liked those posts or commented on those posts or whatever. And that could be it. Calico Bell. Not that Kyle Rittenhouse has money to hire Janet, but that could be what it is. And Linz, is that the trans woman who's under fire for being anti-trans? Is that the British one that's a darling of the Daily Mail? And I can't remember the person's name. Can't remember their name, but and this is an example of, reasonable people can disagree. Ian Runkle, I like Ian Runkle. I respect Ian Runkle. And that's it, Linz. Blair White. That's the one I was trying to think of. But Ian believes that that Rittenhouse didn't commit a crime. Well, the jury agreed. I believe the jury got it wrong. But we're free to disagree. We're free to hold our opinions. So, not J.K. Rowling, Rolana. J.K. Rowling is just anti-trans, not a trans woman herself. So, either way, disappointing, I think. False light. Creating false narratives about my client through your emails intentionally places them in a false light. False light invasion of privacy can lead to legal consequences. You are creating the false narrative that my client is part of hate groups organized against the LGBTQ plus community, which could not be more wrong. Further, you have not provided one fact that supports your claims below. Civil laws and remedies are available in most every state. Once again, where? Show us where. Because, like I said, I'm new to this cinematic universe. I have not seen everything. But one thing that I definitely have not seen, I have not seen any claim that Lauren the Mortician is part of any hate group organized against anyone. This is Janet making stuff up. I have not seen anything about hate groups, about Lauren the Mortician belonging to them. Only that she has liked posts, only that she has interacted with posts that Caffinated Kitti found offensive. Saying that she has interacted with posts is not saying she's part of any group. And saying that, I realize I skipped over my analysis of an important part of the previous section. So what you are doing here is smearing my client and violating her constitutional right to associate with whoever she pleases. So that's the First Amendment. The freedom of association is in the First Amendment, along with freedom of speech, freedom of the press, freedom of religion, the right to redress, petition the government for redress of grievances. Sovereign citizens and First Amendment auditors miss that part. It's, you don't have the right to redress your grievances. You don't have the right to tell the government, you're doing this wrong, do it a different way. You have the right to petition the government for redress of your grievances. They miss a step. But Caffinated Kitti is not violating her Lauren's constitutional rights to the freedom of association. Caffinated Kitti is not the government. Caffinated Kitti can comment on who Lauren associates with. She can disapprove of it. She can comment about her disapproval of it. She can comment that she finds it morally reprehensible associating with certain people. But she is not the government. She cannot violate this constitutional right. The government can't restrict your free speech. TikTok can yeet you off the platform. They can say, we don't like your speech, goodbye. But she's a bad lawyer. Reflections. That's it. She's a bad lawyer. That's how she doesn't understand that. And once again, Janet, my statement that you are a bad lawyer is my opinion. Now, I think that opinion is well grounded in fact, but it is my opinion. Everything I have said here, my legal analysis, is my opinion. If you sue me for my opinion, I will make it very expensive for you when you have to pay my legal fees. It would be a mistake on your part, just like this lawsuit was a mistake on your part. And I have no idea how she passed the bar exam. So, copyright infringement. By claiming fair use in your email below, you have admitted to infringing my client's copyright rights. No, she hasn't. Claiming fair use is not admitting to infringing the copyright. It's admitting to using portions of your client's copyrighted material. But by claiming fair use, you are specifically claiming, I have the right, I am protected by fair use. And reflection, it's filed in the Northern District of Illinois. Unfortunately, it wasn't filed in California because California has an extremely strong anti-SLAPP provision, whereas Illinois, less so. Please refrain from providing me with refreshers of the law in your future communications, as your refresher is incomplete, inadequate, and inaccurate. It fails at every level and is a waste of my time to read. Well, Janet, maybe you shouldn't be providing refreshers of the law in your cease and desist when your refreshers of the law are wrong. Maybe you shouldn't be saying your analysis, as in Caffinated Kitti's analysis, would be a waste of Janet's time to read when you send, I don't even know how many pages this is, but it's entirely too long. A good cease and desist should be, stop. You're doing something wrong. This is how you can fix it. Goodbye. That's basically it. I believe Richard Leibowitz was in New York, wasn't he? He practiced nationally because you can do that as in federal court. Lots of federal courts, as long as you're admitted to federal practice, you can practice. It depends on local rules, but at worst, you have to get local counsel to file for you, but it's pretty easy. You'd need to pay me to read your emails, Bad Scooter. As you have admitted on Reddit, you have seen my videos discussing fair use. My client never gave you permission to use her material, and your statement, I explicitly asked for her permission beforehand and still maintain it, is an outright lie. Two problems with that. Two problems. Number one, as we've mentioned, permission is not a factor in fair use. Permission would imply a license to use it. So, lack of your client's permission, Janet, doesn't impact the fact that it's fair use. It just doesn't. But the outright lie that she asked for permission. She did. She just didn't ask Lauren's permission. She asked the middle. I don't know who it is. It's redacted. But she didn't react to Lauren's video. She reacted to someone else reacting to Lauren's video. She asked permission of the original reactor. Does Lauren get permission from everyone that she reacts to? Everyone that she criticizes as being a dangerous parent or whatever? I doubt it. Does she credit them? That I don't know. But either way. As you have admitted in the TikTok, Instagram, and Facebook post under Caffinated Kitti, that could be you attempting to blackmail me by smearing my name. Once you have your ducks in a row, your Facebook account was monetized. The law places the burden on you, Ms. Kitti, to prove fair use, not me. That's kind of because it's an affirmative defense. Fair use is an affirmative defense. But at this stage, you have to bring suit. If you believe it's fair use, you can say, eat a bag of dicks. This is fair use. Get lost. And dispute the copyright claim. And then it's your burden, Janet, to file suit and prove that it's a copyright violation. Now, it is Caffinated Kitti's burden to raise the affirmative defense, but you still have to overcome that affirmative defense, Janet. Now, of course, I say it's Janet's burden on behalf of her client to bring suit. If it's a false copyright strike, Caffinated Kitti actually can bring the suit for a false copyright strike, for a declaratory judgment saying, hey, yeah, this is fair use. So I have performed a full fair use analysis as is required by law, and my analysis is attorney-client privileged. Guess what, Janet? It's not anymore! You made it an issue in your lawsuit! So Caffinated Kitti can breach that attorney-client privilege. She can demand to see the analysis you did, because that is an issue in the lawsuit that you brought as plaintiff. If you don't have an ironclad waiver of attorney-client privilege, enjoy your disciplinary hearings in front of the bar. You are going to have a bad time with that. And that ironclad waiver, Lauren the Mortician had better have had independent counsel representing her when you got her to sign that. Otherwise, you are going to have a bad time. I'm talking potential disbarment for that issue alone, if not suspension or a big fine. This is bad. I'm, and that ironclad waiver could be a good band name. When I was in law school, I was talking with my friend, and I thought it would be funny to have a band name playing on the rules of civil procedure and have the band's name motion to dismiss for failure to state a claim upon which relief can be granted, but then in all the media just have it written out as 12b6. So a little lawyer joke. Unless a court has ordered me to turn them over, the attorney-client privileged analysis of fair use, they will remain in my files as a protected document. Not anymore. They're discoverable. If you want to engage in good faith settlement negotiations and are willing to comply with all the demands below, I am willing to ask my client if she would be willing to share those with you as part of a full settlement of the civil issue she has against you. She, of course, has the power to say no. That's so it's not extortion, it's a settlement offer, an invitation to engage in settlement discussions. But how is Caffinated Kitti saying if you don't represent her, you're going to damage her? How is that blackmail, but this isn't? That, like, both of those are legal correspondence saying, hey, you need to cut it out. You need to think about settling. You need to think about dropping this. So how is what Caffinated Kitti said blackmail or extortion, but this isn't? Because I mean, neither of them are, but this is more extortion-y than anything that Caffinated Kitti did, at least from what I've seen. So it's, once again, rules for me. Well, rules for thee, but not for me. So my client has suffered significant damage to as a result. To what? Oh, no, sorry. She has suffered significant damage to as a result. So who cares about the damage that as a result has suffered? Maybe work on your English here, work on your grammar, work on not dropping words from your sentence, and I won't ridicule you for it, Janet. But my client has suffered significant damage to as a result of you organizing a group of people to engage in the smear campaign you continue to push and lead others to push, and is currently working to pursue all available legal remedies to protect her rights. So Caffinated Kitti sent me this cease and desist. Is that her organizing people to engage in a smear campaign against Lauren the Mortician? I'm not engaged in a smear campaign. I'm giving my opinion on things that are happening. So, yeah. So, this next, the official demand in the cease and desist is in bold. And as I mentioned, Caffinated Kitti didn't bold this. I didn't bold this. This is how she received it. This is how Jeanette Braun, Janet, formatted it. You are hereby demanded to cease and desist from any further communication with my client or posts on social media, including sending emails or any other forms of correspondence. You are demanded to issue a public apology to my client, recanting all of the false information and overall false narrative you have posted and organized others to post. You are hereby demanded to remove every post you have made about my client on all social media platforms. You are also hereby demanded to remedy the damage you have caused my client, governed by civil rules by monetary compensation. Yeah, about that. If I received that, because she's demanding nonsense. She's demanding that I cease things that I'm allowed to do. That, like, if I receive a cease and desist and I'm in the wrong, I might do it. If I receive a cease and desist for someone demanding that I stop talking about something that I'm allowed to talk about, as long as I'm not defaming them, my gut instinct is basically to respond saying, get bent. You know, send them an eggplant emoji in response. Now, I'm a professional, so that's not what I do. I'd respond, you know, this is, all the videos have been fair use. All of them have been satire or commentary or opinion or whatever, and are protected. None of this is defamation. None of this is false light. Your threats about calling the FBI and your extortion, you know that's what actually looks like extortion here. Your false wellness checks, that's what's harassment. That's it, you know, it may not have risen to the level of a swatting, but false wellness checks can have bad endings. They do damage people. They do harm people. Most cops are doing their best. They are trying to live up to the serve and protect. But you receive a call, a wellness check saying this person is out of their mind. They are, I believe, a danger to themselves and others. The cops are going to be on high alert. It's harassment, and that's it. Real wellness checks can have bad endings. I remember 10, 15 years ago, one of the local news anchors here in Salt Lake, his son was driving on I-15 in central Utah, I think around Beaver, sort of Fillmore, Beaver area. And he pulled over. He was having a manic episode, and the police were called, and they killed him. He was having a manic episode. I don't think he was armed. It had a bad ending, and it didn't have to. Now, it's a dangerous situation. You have someone having a manic episode on the side of the interstate, even in rural Utah. He wanders out into traffic. That can cause bad things. So that they had to be on high alert. But bad things can happen when you call a wellness check. So it's just, and that's it. I think they do need more de-escalation training, and I say that, you know, having watched far too many sovereign citizen videos and First Amendment auditor videos where the sovereign citizens escalate, and then the cops arrest them, and they say, and the sovereign citizens, you need to de-escalate, and why are you so angry? And it's like, that's just gaslighting. That's nonsense. But in general, de-escalation training needs to be every bit the priority that firearms training is. You know, you look at the English police, the average beat cop doesn't carry a gun. It's just the specialized units that do. And why do they not carry guns? Because well, number one, it's not an armed society. But number two, the police focus on de-escalation. That's their priority. So If you have general liability insurance policy or some similar policy, you must send them this letter within 24 hours of receiving it if the policy is to defend you in these actions. Failure to do so may result in the insurance policy refusing to insure your defense. You must also provide me with the name of your insurance carrier in the same time period. I've been meaning to make a video discussing protecting yourself on YouTube, and this goes back to, I think it was, so when CoffeeZilla made his grand expose of Logan Paul for the CryptoZoo scam, and Logan Paul threatened to sue, I think that's when I had the idea to make this video, but I've been procrastinating. But it was also a Tozy being sued by BitBoy Crypto. Funny how crypto leads to so many defamation lawsuits. But discussing how to protect yourself online, well, as a content creator specifically. And one of those things is insurance. It's that we've talked about rules for thee, but not for me. This is a do as I say, not as I do at the moment. But the general gist of that video would be your YouTube channel should not be owned by yourself. It should be in an entity, a separate entity, a corporation or an LLC or whatever. And with you as an employee, CEO, receiving a salary. So, don't do anything that would allow them to pierce the corporate veil, and have a corporate insurance policy that has a duty to defend both the corporate entity and its employees, is the basic gist of what that video would say. So yeah, and liability insurance, that's important. If you're a YouTuber, you should probably have it. Further, because you believe only guilty people will try to hide from the real questions or something similar, as you posted in a video on TikTok, here are a few questions for you to answer. Based on your logic, if you are not guilty of anything, you will answer, Miss Kitty. This isn't even passive aggressive. This is aggressive aggressive. And once again, I would probably respond to all of these with eggplant emojis. Maybe with a starfish emoji next to them. Who are the people in your team? Identify by full name, email, social media handles, and full physical addresses. And once again, I wouldn't include, I wouldn't give any of this. It's, if you want this, you'll have to survive a motion to dismiss and get it in discovery, because yeah, it's nonsense. And that's the problem with that, Kevin, is I know enough about tax law to be dangerous in that I'm not an expert on tax law. So I'd be afraid of being too Dunning-Kruger on that. My Opa was a CPA focused mainly on tax, at least in his private practice. He did audits in his younger days, but practically my entire lifetime, he was sole practitioner doing tax work, and he didn't until he was 92. But my cousin is an accountant, could be a CPA, but he never took the test. But I'd have to get help to do a proper tax video. Maybe pocket watching with JT would be a good person to do that with. But number 2, who are the smaller creators in your statement? I do understand how you have reached out with cease and desist to smaller content creators speaking. Identify by full name, email, social media handles, and full physical address. What platform did they contact you on? What date did they contact you on? Send me screenshots to support your answers. And that doesn't matter. It's, I mean, Janet should know who she has struck, what content creators she has struck. And Kitti, Caffinated Kitti, saying, I know you've reached out with cease and desist to smaller content creators. That doesn't mean she's interacted with them. That doesn't mean she has their full name, email, and physical address and nonsense. I mean, you know, I know that Delete Laws has struck Team Skeptic, but that's because Team Skeptic has talked about it on his channel. Other than commenting on his videos, I've never interacted with Team Skeptic. I couldn't tell you his email address, his physical address. I mean, I could tell you his full name because Delete Laws doxed him, but this is nonsense. So, number 3, what are all of your handles / usernames on TikTok, Reddit, Instagram, and Facebook? Caffinated Kitti. All of it is different on Reddit, as far as I know. 4, why have you gone off-brand with your smear campaign against my client? You proclaim to be a demon and villain who traumatizes men, and you use the hashtag #TraumatizeTheMen on the majority of your videos. Why are you smearing my client, who is a woman, and without even trying or having an intention to do so, caused such trauma to a man, even without identifying him, that he went on a social media posting tirade wrought with defamatory statements about my client and told the public himself he was the one my client was talking about? I assume the man she's talking about is Jamie Grayson, which, like I said, I'm still learning the lore, but it would appear that that Lauren was at least insinuating that Jamie Grayson was, shall we say, a creep with children because he's a gay man without children but has car seats at his house because it's his job. It's his job to determine the safety of car seats. So it wasn't Caffinated Kitti that caused him to go on an online tirade. It was Lauren calling him, or at least insinuating, that he's a creep. This is, once again, this leaves me speechless. This is victim blaming. This is burden shifting. It's, why did you traumatize him? When it was my client that did it. But why did you talk about it? That's what did it. My client did the heavy lifting, but you called attention to it. Why did you do that? Why are you such a terrible person? And once again, traumatize the men. You proclaim to be a demon who traumatizes the men. So why did you go after my client? She doesn't have a penis. Why did you go after her? Oh, once again, traumatize the men It's a brand, it's shtick, it's satire, it's like I said, Caffinated Kitti has been lovely to me. And last I checked, I am a man. Her content is about staying safe as a woman in unconventional ways. Now, but that doesn't mean if a woman attacks a man, letting it slide. And especially Jamie Grayson, as far as I know, is a gay man. Once again, I'm still acquainting myself with this cinematic universe. I know Jamie has commented, so if I'm wrong, Jamie, I apologize. But you know, part of being a good ally, which I believe is also part of Caffeinated Kitti's shtick, part of being a good ally is calling out anti-gay rhetoric, which calling gay men creeps would be such rhetoric. And when I say creeps, that's, you know, child predators. That, yeah, that's it. It's the old-fashioned, how dare they let a gay teacher teach my kids in school? How dare they let a gay man determine which child seats are safety? Shouldn't that be a mother's job? He doesn't have kids. How can he possibly know what's safe for them? And that's it. Jamie, I think, needs to sue. He needs to do it. And frankly, Jamie, if you do sue, you'll have support. I mean, it's expensive. It's expensive. Taking it through to summary judgment could be 6 figures. But I believe you'd have the support, and you'd have Lauren the Mortician paying your lawyers in the end. So, you know, even if you don't get a whole lot out of it, which you should, you've got damages. It was a monetized Facebook account as far as I know. So you've got damages and you can show damages. But that's getting a case to trial can be multiple hundreds of thousands of dollars. Getting it to summary judgment can be $100,000. You look at, you know, the delete laws, the Massachusetts case, DeCastro versus Abrams, getting the motion to dismiss cost Kate $70,000-$80,000. That was without discovery. That it's and that's it. That's why slap laws are important. If you have to pay $100,000 to protect your free speech, is there such thing as free speech? But even anti-slap, that special motion to strike, that's what an anti-slap motion is, that can be $10,000 right there just to get that one motion. So it's an expensive game. I don't deny it, but most anti-slap laws, they have fee shifting arrangements where, you know, if you bring a slap suit and it's dismissed on a slap motion, you're paying. So thank you, Biff. And I need to thank you for something. You gave me good information. Can't remember what it is, but you keep up the good work too. But moving on. So, is your entire online personality and brand a sham and facade? You claim to receive great joy from inflicting emotional distress on men. How much of a lie is this? What is your connection with Jamie Grayson? And once again, she doesn't understand. I mean, she even puts it. Is your online personality and brand a sham and facade? Yes. Yes. It's called entertainment. It's called acting. It's called shtick. It's called whatever you want to call it. Whatever you want to call it. It's entertainment. Like I said earlier, Star Wars isn't a documentary. Mark Hamill wasn't really, force pushing and jumping 20 feet in the air, and it was a persona. It was acting. And as far as I know, they haven't been served yet, but they're still within the time to serve them. So I don't know why they haven't, but we'll see. Like I said, I don't know. It's not on the docket yet, though. So as far as I know, they haven't been served. So next up, when did your friendship/relationship with Mr. Grayson begin? Who says they have a friendship or a relationship? She's interacted with him online. She's talked about his video. But once again, what does that matter? Is she only allowed to stand up for her friends? I've exchanged a grand total of 2 emails with Caffinated Kitti. Does that mean we're friends and have a relationship? It means I've interacted with her. Now, as I've said, she has been lovely in those emails. But I don't know that we'd even count as acquaintances yet. What I don't know what Janet means and what possible benefit she can get by, tell me about your relationship, your friendship with Jamie Grayson. It's nonsense. Have the girlies been served? It's like I said, I haven't seen them. They obviously all know about the lawsuit, but that isn't service. But I don't know. I haven't seen them confirm they've received service, and it's not on the docket that they have received service. So provide me with the name and link to the Discord server where you are collaborating with others to share the truth about Lauren the Mortician. That's the first I'm hearing about a Discord server, especially collaborating with others. I don't know where that came out of. Explain what your bug/worm parties are and why you throw them. What the hell does that have to do with anything? I don't know what that is. Like I said, this has been my introduction to Caffinated Kitti. I fully admit I'm not the target demographic of any of these creators being sued here or suing. I don't know what the bug or worm parties are. Has she talked about having a bug/worm party in celebration or about or to damage Lauren the Mortician or whatever? If not, why even bring it up? What does it matter? Is this just another example of Janet not realizing that this is a persona, that this is done for entertainment? I don't understand her motivation here. This letter is not intended to be an exhaustive statement of my client's civil rights, remedies, claims, or defenses, and she expressly reserve all rights and remedies available to them under the law. Any settlement of my client's civil claims against you does not settle her criminal claims against you. Those are to be handled through the appropriate authorities. Yeah, and if you call the appropriate authorities, they should get after you for filing false police reports. Because there isn't any criminal activity. At least I haven't seen any. You have 72 hours from the date of this email to comply with the demands above. Answer the questions asked. Issue your public apology. And have 7 days from the date of this email to contact me to remedy the damage by monetary compensation that you have caused. My client expects immediate and unequivocal compliance. I highly encourage you to seek legal counsel. And I mean, the number of times she said, you need to get legal counsel. You need a civil attorney. You need a criminal attorney. You need a maritime attorney. Once she hires that attorney, they're going to laugh their ass off about this cease and desist. They're not going to be intimidated by it. Your intention, it would seem, from this gish gallop of nonsense, this gish gallop of jabberwocky, is to intimidate her into a settlement. But in it, you tell her, you need to get a lawyer before you even think about acting. And that lawyer is going to say, settlement? She can pay you. So the number of times she said seek counsel, once she does, she'll just be reassured that this is nonsense, and yeah, you might get sued, but you're going to win. It's going to cost Lauren money, and there's a really good chance she's going to have to pay you damages, at least to compensate your attorney. So, yeah. Potential civil litigation hold notice, spoliation of evidence mitigation. This letter serves as notice for a potential litigation, and as such, you must not destroy any evidence and are required to preserve all electronic data, advertisements, and any documents that pertain to this matter. Destruction of any evidence, including any evidence on your mobile devices, can be considered spoliation of evidence, and we will pursue the maximum remedies at law for such behavior. Immediately take all steps necessary to prevent the destruction, loss, concealment, or alteration of any paper document, or electronically stored information, and other data or information generated by and or stored on computers and storage media, e.g. hard disks, floppy disks. Yeah, Janet, she's using floppy disks. So, Jackie Flores, this is the cease and desist letter that Caffinated Kitti received from attorney Jeanette Braun, aka Janet, for Lauren the Mortician. So not all the girlies, but this basically was threatening the lawsuit against the girlies, but this was specifically Caffinated Kitti. So hard disk, floppy disk, backup tapes, etc., and preserve the email or text messages related to the above captioned actions, including all parties' claims and defenses, any documents relating to the video, any communications between or among your team and or other employees relating to the same, any communications with TikTok or other third parties relating to the same, and any communications about TikTok, my client, or my client's business, including all communications made via social media and email as discussed further below. And yeah, don't destroy documents if in anticipation of litigation. That basically, if you go out deleting documents after you receive this, there could be what's called an adverse inference. Basically, the court could instruct the jury, this was deleted, we believe it would have said this and would have helped us prove this. So the jury is instructed to determine this fact as the plaintiff's claim. But it works both ways. Lauren the Mortician and Attorney Braun also can't be spoliating evidence. They can't be deleting emails. Janet can't be deleting her analysis of fair use, which she says in this is protected by attorney-client privilege, but now is not. I mean, technically it still is until the court rules it's not, but the court will make such a ruling because it's an issue. It's an issue in the lawsuit. Suing with your client as a co-plaintiff is going to result in a bad time, Janet. Yeah, 911 calls, dash cam, body cam, it can lead to brain malfunctions sometimes. And the smoke signals, that might actually be a good way to communicate, because you can't delete things in contemplation of litigation. So there's a certain point where you have to start preserving things, which is why it's a good practice to not leave your email full. Read it and delete it. Depending on the rules of preservation. As I mentioned, I did one of my summer internships with the SEC, and as a government entity, we had to preserve our emails. We literally had to save them as files, and it was discoverable. Now, I could delete like the daily update email that went out SEC wide, but if I sent or received an email relating to a case, I had to keep it. I had to save it. But you don't have to save conversations unless it's taped. It's it's like a fart in the wind. It disappears. That's why there's wiretapping laws. Smoke signals can't be preserved. Semaphore can't be preserved unless it's videotaped. So if you want to have things that won't be read in court, you might use smoke signals or semaphore or spoken word and make sure it's not preserved onto a fixed media that can be used in court. You should anticipate that much of the information subject to disclosure and responsive to discovery in this action is stored on your current or former computer systems and other media and devices, including personal digital or data assistants who still has a PDA. Jesus. That's almost as outdated as floppy disks. And I'm old. I used floppy disks in my undergrad, but I also used thumb drives in my undergrad. It was that transition period. Voice messaging or voicemail systems, online repositories, and cell phones. ESI should be afforded the broadest possible definition and includes, but is not limited to, all digital communications, e.g., email, voicemail, text messages, and instant messaging, word processed documents, e.g., Word and Word Perfect documents, and drafts. And that's it. I think pretty much everything pertaining to Lauren the Mortician is now discoverable. I mean, she might have some things that she can preserve, but she's made it an issue in litigation. So, and frankly, by agreeing to be a co-plaintiff with Janet, Lauren has waived that attorney-client privilege, or at least she's effectively waived it. She might not have known she was waiving it. I don't know. I haven't spoken to her, and I won't, because once again, this isn't a petting zoo. She can leave a comment if she watches this. You know, Lauren, did you sign a waiver? Did you know that you were waiving attorney-client privilege with Janet? If not, you should go talk to another lawyer, because you might have a case against her for malpractice. Janet, how's your malpractice insurance? I hope you're fully covered. And I can't read that whole wall of text about what she considers discoverable. But you are also requested to preserve and not destroy all passwords, decryption procedures, including, if necessary, the software to decrypt the files. You know, I was at my general doctor's appointment yesterday, and in order to fill prescriptions, it was a PA, physician's assistant. She had a thumb drive that she had to put in her computer to allow her to fill prescriptions. So software to decrypt the files. And thank you for the super chat, Jermaine. Yeah, my personal opinion, like I said, I'm lazy, so I haven't filed a grievance, but I believe she has violated multiple of the Illinois rules of professional conduct. And that's, you know, threatening criminal charges, especially bogus criminal charges, to basically force a settlement in a civil case is a violation. Sending Caffinated Kitti's mother the correspondence, excuse me, that could be harassment. It could be considered threatening. I believe Janet is very unethical. Now, Janet, once again, you heard me say, I believe you are unethical. That's my opinion. Opinion is protected. I keep repeating this because I believe Janet needs it repeated. That opinion is protected speech. Now, I say opinion is protected speech. Now, I worry that some content creators take that a little too broadly. I can't remember who it was I was watching. Like I said, I'm new to this cinematic universe, but I have been consuming a lot of content around it. My YouTube algorithm does not know what is going on right now. It just doesn't. But one of them was talking about protected speech and why content creators always, in my opinion, I believe, and yada yada. And I think some people take that a little bit too far in that they make statements of fact, but say, in my opinion, or allegedly, or at a protective modifier at the start of the sentence. But the reality is they're still stating it as a factual allegation. And that's not necessarily protected. So I think there's a lot of people that need to be a little bit more careful. And that's it. Turtle Boy. For those of you who don't follow, I mean, I've never covered Turtle Boy, but he's a loudmouth in the Boston area that he's latched on to the Karen Reed murder case and he's basically he's in jail right now for witness tampering, and he believes, well, I'm not tampering, I'm not intimidating the witnesses, it's my free speech and it's my opinions. And it's like, yeah, but you're still contacting witnesses to try to stop them from testifying or to get them to change their testimony. That's not protected, no matter what protective language you use. And you're lucky, Brittany Edwards. Turtle Boy is awful. I don't watch him. I just, some of the other content creators I do watch about sovereign citizens or First Amendment auditors or whatever generalized lolcows cover him, and he's awful. He's recently he's trying to be a wannabe Andrew Tate, I believe, but also, you know, he's decided that the free Karen Reed movement is his cash cow, but it's landed him in jail. And you know, I saw videos he was doing before he was arrested, and I was like, how has he not been arrested for witness tampering? And he has been. He was arrested on information. They indicted him after he was arrested and brought even more charges. So, and I think he's going to have a bad time at trial. I don't see him having a winning defense. So, but yeah, you should not pack, compress, purge, or dispose of any file or any part thereof. So basically, she wants the metadata preserved along with the documents. You are further requested to immediately identify and modify or suspend features of your operations, information systems, and devices that, in routine operations, operate to cause the loss of documents, tangible items, or ESI. Examples of such features and operations include, but are not limited to, purging the contents of email repositories by age, capacity, or other criteria, using data or media wiping, disposal, erasure, or encryption utilities or devices, overwriting, erasing, destroying, or discarding backup media, reassigning, re-imaging, or disposing of systems, servers, devices, or media, running antivirus or other programs that alter metadata, using metadata stripper utilities, and destroying documents or any ESI by age or other criteria. Direct all future correspondence you want to send to my client to me. Very truly yours, Jeanette M. Braun, Esquire, attorney for Lauren the Mortician, aka Janet. And And that's it. He thinks, hey, I'm not a party to this case, so I can contact the witnesses. I can get them to change their testimony. But he's wrong. He's a moron, turtle boy. He just doesn't understand the law. But he's not a lawyer. It's not his job to understand the law, but it's his job to follow the law. So yeah. But so the direct all future correspondence to me and not my client. Yeah. Opposing parties are not supposed to contact represented party directly. So now that the girlies have a lawyer, Janet can't contact them directly. She has to direct her contact to their lawyer. Her lawyer, or the girlie's lawyer, has to send contact to Janet, not to Lauren, and back and forth. And so, and CC, so this was CC'd to Caffinated Kitti's mother. And yeah, that's, to me, that's just harassment. Because unless Caffinated Kitti's mother was engaging in some of this activity, the cease and desist should not have ever been sent to her. It's just harassment. I can't think of anything else it would be. And I just don't understand it. So it being a slap suit, that's not the issue for the bar, I don't believe. I think the issues for the bar are going to be the violations of the Illinois Rules of Professional Conduct, which includes the threatening criminal sanctions for a civil case. That's going to be a problem. I think the waiver of attorney-client privilege could be a major problem, but that's up to Lauren to bring. It's just, yeah. And I had a total of 1 slap bracelet, TNPR, when I was in 1st grade. And that was a very, very long time ago. What's crazy is my niece and nephews got some a year or 2 ago because they came back in for a little bit. So it's not just 90s kids that would get it. It would actually be, and for me, I'm talking very early 90s, 1st grade, like 1990. But 2020s kids get it too. And yeah, I definitely see sanctions in her future. It just one way or another that there's gonna be something. And there very well could be counterclaims. I mean, I realize, at least as far as I've seen, Janet and Lauren the Mortician haven't brought any copyright lawsuit against Caffinated Kitti. But even absent that, this lawsuit would be Caffinated Kitti's opportunity to bring counterclaims for the false copyright strikes. So she very well could countersue here, and even just for that. And so my niece and nephews definitely wouldn't get GoldenEye. So the slappers only, that's the mode where you couldn't have guns. You just went around slapping each other, right? I didn't have a Nintendo 64, so I had to rely on friends to play GoldenEye. But yeah. So that's the cease and desist. I don't like. I don't know if that would be worth suing over the false wellness checks. Like, it's harassment. I don't know that it's worth suing over. It could be worth making a criminal complaint about, but it's yeah, and that's it. She's in big doo doo. She's what you remind me of, since we've mentioned Star Wars multiple times. And speaking of Star Wars, before I get to addressing this, so I did the criminally wrong, action yesterday of I rewatched The Force Awakens last night, and it occurred to me there's something that doesn't make sense. And I realize the sequel trilogy has lots of things that don't make sense, but I'm talking something stylistically that doesn't make sense. So the character Finn, played by John Boyega, he plays him with an American accent. Now, his general Hux, played by Domhnall Gleeson, who is Irish, but plays General Hux with a British accent. His captain is Captain Phasma, played by Gwendolyn Christie, who is British, and plays Captain Phasma with a British accent. So why does John Boyega, who is British, play Finn with an American accent when his commanders all have British accents? It doesn't make sense. It doesn't make sense to me. But getting back, I wonder if Janet realizes she's in big doo-doo. I just think that would be something Jar Jar Binks would say, Misa in big doo-doo. And that's the thing. The Empire colonizes lots of planets, but this is the First Order, and they kidnapped Finn as a child. So he would have developed his accent within the First Order and with his commanders having British accents. So it just doesn't make sense to me. Not that it has to make sense because it's fictional, but it just doesn't make sense. So either way, it doesn't matter. The sequels are entertaining but problematic. So I think, though, that's probably a good time to end the stream because we've been going almost 2 hours and 45 minutes, and I realized it was probably a stretch to get through this and the wellness checks video because I am talkative, and adding the chat in slows things down, but also makes it more fun. And that's actually a good idea. He could have been cocky because, the higher up you get, the posher accent you should be in the First Order. So the lowly grunts should have been Cockney or Scouse or Geordie. Why did it take me so long to think of Geordie? I lived near Newcastle. My master's degree is from Durham University, for those of you who know where that is. But yeah, so going forward, I think I'm going to put the that video, the the wellness checks as a separate video. I might live stream it, I might not. I'm thinking tomorrow I'm going to do something completely different. I realize lots of you who are my regular audience have already seen it multiple times, but there was the judge attacked in Nevada and the video released by our Nevada judges. So I think I'm going to try to do that as a live stream tomorrow. No guarantees. It might just end up being a video, but you know, I think that's something I need to cover, especially since I've got more to add to it. I've got other stories. So yeah, so that's probably going to be the next video or live stream or however I do it. And then we'll do this, and there's plenty more. Like I said, I still plan to at least try to review some of the videos to see if they, in my opinion, are fair use, and review the posts to see if, in my opinion, they are transphobic. And so, yeah. But with that, thank you for joining me. Thank you to all of you who became members since it's brand new on my channel. Thank you for those of you who sent super chats. I really do appreciate them. And I hope I didn't miss any of them. I tried to stay on top of them. I try to stay on top of chat, but I realize it's, you know, 2 screens. It's hard to see. And from what I've seen, Cece Suarez does fair use. She's brand new to me, but everything I've seen from her, fair use. So with that, though, do all the YouTubey stuff. Like, share, subscribe, bribe your friends and family to do the same. And I will see you next time. Bye-bye.